All right, folks, it's time for our favorite podcast, Cut to the Chase. And that's what we do. We cut to the chase. I'm bringing William Ogle on to talk about tobacco litigation. And William has been involved in tobacco litigation for a long time, has a history going back to the 1980s. When I was a young attorney, I didn't think anybody could win a tobacco case, but over the years I've found out that plaintiffs do win. And this is one guy that's won them all. So I brought him back to talk about what's going on with tobacco litigation. There's some updates from the Florida Supreme Court, and maybe even talk a little bit about Juul and his history. So how are you doing today, William?
I'm doing real well, Greg. Thanks for having me on.
All right, so let's start from the beginning. Like, when did you get involved in tobacco litigation, and give us some of your highlights?
Well, I was involved sort of inadvertently as a brand new lawyer just out of law school. I was asked by the lawyer I was working with, who had a lawsuit against the tobacco companies in a different state, but they asked me to handle one of the depositions. I was amazed. I just was so impressed because the tobacco companies had to rent a large conference room in a hotel, the largest hotel in that town, just for all the lawyers that they brought to that one deposition of the plaintiff in that case, which was ultimately dismissed by the courts. But the guy I was working with, it was in the 80s, and he was a crusader, one of the early proponents of suits against the tobacco company. That was the first one that I was involved in. And then here in Florida, there was a sort of a resurgence, not really a resurgence, but a sort of an explosion of litigation in around 2004, 2005. There was a guy in Jacksonville, Woody Wilner. I don't know if you heard of him, and Howard Acosta in Tampa. They were asbestos defense lawyers. And a fellow down in your area, Alan Feingold, who's a pulmonologist, he was an asbestos defense pulmonologist. And one of the defenses in asbestos cases was that people were smokers, and that's why they got lung cancer. Anyway, they started suing tobacco companies. We started doing the same thing in Daytona Beach area. And we never got to trial in those days. The Engle class action came in, went to the Florida Supreme Court, and then our individual cases started becoming available for trial in around 2012, and we've tried 4 cases now.
Yeah, so the first name that I kind of got on my radar with the tobacco was Stanley Rosenblatt and his wife, I believe,
Yeah.
Susan. And so what was the Engle? They were tied in with the Engle litigation, right? Was that their baby, so to speak?
Yeah, Stanley Rosenblatt and his wife. That was about the same time that Woody Wilner and Howard Acosta were beginning to try cases, individual cases, and we were accumulating some individual cases in Daytona. So Howard was a medical malpractice lawyer in Miami, and he and his wife worked together, and they decided they were going to file a class action against the tobacco companies for all the smokers in America. There was another one, a similar case, sister case there was a class action in New Orleans, went up to the 11th Circuit. I guess maybe that was the 5th Circuit. Anyway, that was called the Castano case, and that resulted in a huge settlement. And so Howard, he worked and worked, man. He worked for years on that, back and forth, and then he finally got to trial in Miami. The class was whittled back down to all the smokers in Florida in a specified time period. Howard and his wife tried it against them. The tobacco companies sent, just armies of lawyers from everywhere: New York, Winston-Salem, Chicago, Wichita. They poured everything they had at Howard and his wife, and they won. Howard and his wife won it.
It was Stanley. It was Stanley, not Stanley, not Howard.
Howard Rosenblatt.
I thought it was Stanley.
Oh, Stanley Rosenblatt. Oh,
Yeah.
I think Howard's in there. Yeah, somewhere. Yeah, Stanley Rosenblatt. So anyway, they went up to the Court of Appeals. It was affirmed in part, and it was overruled in part, and it went to Florida Supreme Court. They affirmed in part, overruled in part, and to separate all the cases that had to be tried individually. But meanwhile, Stanley did very well, in that and was just tired, and he got out of it at that point. And then a lot of firms around the state, have been trying individual cases, and we're one of those.
All right, so the Engle case starts off as a class action. To me, I'm thinking class action, personal injury, you got to prove individual damages, you got to prove that, whatever was done wrong by the tobacco company, you relied on that and to your detriment. So I never would have thought you get a class action out of that. But there was some lasting ruling in the Engle litigation that was basically the Florida Supreme Court said that they were going to apply that one particular ruling across the board.
Yeah, you're right. And so you predicted exactly what the Florida Supreme Court would do, and for the very reasons that you cited, that every individual has to prove that their injuries were caused by the tobacco company. So they have to be tried individually. But there was the Florida Supreme Court did hold the finding of the Engle jury findings that the tobacco companies conspired together to conceal information from smokers with the intent that they would then keep smokers addicted who would otherwise quit, that they were negligent, the products were defective and unreasonably dangerous. So you have all these good findings that are res judicata in subsequent individual cases. So people have thought that gives them, a leg up, a real advantage for the plaintiff. In my experience, the two cases that I've won in 7 figures and 8 figures, neither one of those were Engle cases. Really? They were just straight up garden variety tobacco tort cases.
Yeah. So what apparently the Florida Supreme Court just came back with a ruling sort of undercutting their previous rulings that you just went through. And I guess nowadays, Supreme Court's and precedent doesn't seem to really matter. What did they do recently, and what's your take on that?
Well, okay, yeah, I think precedent does matter some with these guys. I think it does matter, but I think they have somewhat of a different take on some of the issues than the former justices did. So what the Supreme Court has recently done is they have effectively overruled a first DCA case that was called Martin. So, and Martin was one of the early Engle appeals. And what Martin said was that on this issue of reliance, right, you mentioned it, that each individual claimant has to prove, if they want to prevail on the issue of reliance, they have to prove that individual relied upon the concealed information, the concealment of the tobacco companies to their detriment, and therefore they were damaged. The first DCA ruled that the overall pattern of tobacco company propaganda about smoking is, so the jury can infer from the fact that the tobacco company advertised their cigarettes, they put out all of this misinformation, and they conceal the true facts about the addictive nature of cigarettes and the fact that they cause cancer. Just that general environment is enough for the jury to infer that this particular individual plaintiff relied upon it. And what the Supreme Court recently has done is said, no, you can't rely upon the activities of the tobacco company in general and infer from that an individual relied. You have to have evidence that that individual plaintiff relied upon something that the tobacco companies did. For example, if let's say the individual plaintiff switched from non-filter cigarettes to filter cigarettes, you can infer from that the smoker, who's now deceased, thought that filter cigarettes were safer. We have proof that they're not safer. They were not safer. They never were safer, and the tobacco companies knew it. So concealing the dangers of filter cigarettes as compared to non-filters, that's sufficient. And the switch of the plaintiff from non-filters is enough to do that. The problem in proof that a plaintiff like us, plaintiffs like ones that we represent have, is that the plaintiff is usually not here anymore. They've died. How are you going to prove that they relied upon something that tobacco companies did without being able to have the inference that if tobacco companies spent billions of dollars to get this message out that smoking is not harmful, then from that you can infer that this individual relied upon it. You can't have that anymore. So you've got to have testimony or action, testimony from one of the survivors or action by the plaintiff that would be sufficient for a jury to infer that this particular plaintiff relied upon it. It just makes it a lot harder for the plaintiff.
All right, so back in the late 20th century, there was, I think, another class action against the tobacco manufacturers, which resulted in a settlement where they basically agreed to do some public service announcements, and they weren't going to market to the youth, minors.
They've always marketed to minors. They still market to minors. That is, sometimes people, but the answer to that is yes. There were the attorney general cases. The state of Florida was one of those states, and there was a massive settlement with the tobacco industry, and in addition to sending, exchanging to funding various programs with the states, they agreed to certain things. And one thing they did in that settlement is they were required to do is to give over all their previously secret documents into a clearinghouse. And it's those documents that allow us to win these cases. Without those documents, we couldn't be winning these cases.
And those documents essentially show that they are marketing falsely.
They show two things. Two main things. They're marketing to 12, 13, 14-year-olds and have been doing it since the beginning of their industry. And they're still doing it. That's what those documents show. And they also show the tobacco companies have that a cigarette is not a natural product. It's a manufactured product in which the nicotine is very carefully and specifically adjusted so that people stay addicted.
All right,
it's an
so
addictive device, and they know it.
So, and Congress knows that, so they're manufacturing a product, they're intentionally designing it to be highly addictive, and they're marketing it to 12-year-olds.
That's right.
That's their game plan. That's their marketing. That's it.
And it was and still is. And that's how we win these cases. And it's true. We have it. We have the proof in the documents.
All right. So if somebody is listening to this program and their spouse died recently from lung cancer and they were a smoker, should they call you, or are they out of luck because of the new Supreme Court ruling?
No, they should call. No, that Supreme Court ruling does not prevent us successfully pursuing a claim for the very reasons that you said. I mean, nobody really, statistically, so few people start smoking after 18. It's vanishingly small number. The tobacco companies know this. They've known it forever. After you become 18 years old, your brain is more mature, and you're not going to start smoking. You understand what it is. When you're 12, 13, 14, 15, 16, they groom them at 12 or 13 to start smoking at 15, 16, and not realizing what addiction is, thinking that, okay, it's a cool thing. I'll smoke a few of these. And then when I get, a year from now, I'll stop. And then when it comes time to stop, they can't stop because the cigarettes have been, as you say, designed, engineered to be an addictive product. And so they've got a lifelong customer who has a 50-50 chance of dying from a tobacco-related illness and has a 100% chance of having a very unhealthy old age as a result of using those products.
Now, what is the likelihood of getting enough punitive damages that you could effectively shut down the industry? Is that plausible?
No, well, not in my lifetime. I mean, they're making so much money, Greg. I mean, they're making more money today than they've ever made. They're
It's
making
really,
more, not only in America, but especially abroad.
and Congress, there's no chance. They're not going to do anything.
Not this Congress.
Yeah. Well,
But
all right. So now what I see is, 21st century, now there's this Juul thing. What, I mean,
okay, that's
how did that get approved? And are they doing the same? Is it the same cast of characters and the same marketing plan?
the answer is absolutely yes. But let me back up for just a minute. What you said about putting them out of business. That's one reason they're going to Juul is because they do have long-term concerns, especially about the legal side of it. They make about $13,000 net on every smoker. Okay, 13,000 is all they make, but they have so many of them, it becomes billions.
Yeah. Wow.
Okay, so if they make 13,000 per smoker, and half of those people are going to die from smoking related illness. Okay, so they're getting so for $26,000, they're facing one lawsuit that could be $1 million each. So their business model is not working. Long term, it's not going to work, and they know that.
Yeah.
So now they want to switch over to these non-smoke products. The thing about it's the same deal because they are damaging to people's health, and they are probably more addictive than conventional cigarettes, and they are definitely marketing to children. We had R.J. Reynolds in the case in Orlando just a couple of years ago sent their corporate representative to tell the jury about how great their company was because they've gone over to these non-conventional products, the Juuls, and then RJR has their own brand. And so in cross-examination, I was able to ask him, well, are these products addictive? Yes. Yeah, and they're harmful. He said, well, and I said, well, don't they cause some diseases? He said, well, yeah, they do cause something called popcorn lung. Popcorn lung? And I said, and so you're not marketing these to children, though? No, these are just to older people who are trying to quit smoking. So you're telling us that a 40-year-old man wants a bubblegum flavored Juul? He wants, tropical flavor, bubblegum flavor. That's ridiculous.
Yeah.
They're marketing to 13, 14-year-olds. That's what they're marketing it to.
That's crazy. All right. So let me ask you this. Somebody's 22 years old. They're hooked on cigarettes. Now they're moving over to Juul and they bought into this, switch over to Juul. That'll solve the problem. You'll get off everything altogether. Say they did that for a couple of years and they can't get off it. Do they have a claim? Would you take that case just in general, those type of things?
Yeah, I would take it because Juul has been marketed fraudulently, as a safer alternative to cigarettes. They're not safer. They're as addictive, if not more. They certainly cause lung problems and other problems, some of which are not yet discovered, but they will be discovered, just like it took, years for cigarettes to really be identified for what they are. But someone is 24 years old and now he or she addicted to Juuls, had been addicted to cigarettes, have been groomed and hooked by the tobacco companies at 15 or 16. I think they have a claim.
I'm going to
Of course,
put you on
the jury's going to say, why don't you quit? That's the negative side of the case for us. The jury almost always finds some comparative negligence because they say, hey, why don't you quit? Why didn't you quit?
So in your experience representing people that, smoke cigarettes, why don't they just quit?
They're addicted. Cigarettes, the addiction to cigarettes is as strong or stronger than the addiction to heroin.
Wow.
Everybody knows someone who's quit smoking. Some people are genetically more inclined to addiction than others. I'll tell you something personal. I watched my father. He started smoking at 12 years old. and then he was in the Army in World War II. So, it was reinforced
Yeah.
in the Army setting. He was a physician, a doctor, an MD. He knew perfectly well the dangers of smoking. I watched that man try to quit. He tried to smoke a pipe. He tried cigars. He tried chewing gum. He tried everything, and he couldn't quit. Some people just can't quit.
Yeah. Is it, in your opinion, the most dangerous consumer product?
Absolutely, bar none. Over 360,000, closer to 400,000 people die in the United States alone every year. That's over 1,000 people a day. It's worse than COVID.
Yeah.
It's completely useless.
Oh,
I mean, there's no redeeming factor. COVID, we've gotten rid of COVID, or we're in the process of getting rid of it. We didn't deliberately foist COVID upon the market. The tobacco companies are spending billions to keep people doing something which is no redeeming social value.
Yeah, I mean, from the time the Surgeon General, finally fessed up and said, that cigarettes are bad, to now, do you think anything has gotten better in this whole, I don't even know what to call it, this whole world of smoking?
Yes. We have a graph that we show the jury, and there's a peak in smoking and lung cancer, and the graph lines go right together. And that peaked about, I'm going from memory, so I'm not sure, it was, something like in the latter part of the last century. Cigarette consumption in the United States is going down.
All right, well, that's good. I guess, all right, I'm waking up every morning and saying, Greg, find something positive. Find something positive. All right.
Yeah, there's an end in sight. It's improving. The tobacco companies are not getting better. They're not getting any better. They're just, it's mass murder, really.
Yeah. All right. So go ahead. I'm sorry.
Well, the public is getting wiser.
Yeah. Well, you would hope at this point, whatever, six decades later. What do you have any trials lined up? Anything on that front?
Yeah, we have some trials this fall. We've been closed out because of COVID.
Yeah.
But we have trials this fall. Unfortunately, some of the cases we have are the people are getting, there were so many cases filed in the Engle system that they clogged the courts up, and it's taken us a long time. Some of the cases that we signed up in early 2000s are only going to trial now. The people, it's hard, but we have some new cases and so they're having to stand in line, but we have some new cases that are ready to go to trial. And we have a case that we won in Orlando that's going before the Florida Supreme Court on June the 9th. And that'll be broadcast through the Florida Supreme Court system, the oral argument, and we're hoping to hold that in. Jury awarded $16 million. That was the case where I told you they brought a tobacco company representative down to try to justify their marking of these vape products.
Yeah.
And he had to admit that they got bubble gum and tropical and cherry and grape flavors. Who is that for? And he had to admit that they were fully addictive as any other cigarette product, much more so than, say, pipes or cigars, and that they cause terrible harm to people our lungs are not made to ingest smoke.
Yeah.
That's not, let me tell you this real quick, Greg, because this is something that I didn't know that turns out to, I think, is important. If you get around a campfire, right, and you're roasting whatever, marshmallows, and the smoke gets in your face, you don't like it.
Yeah.
Right? You move.
Yeah.
So you don't have to inhale it. That's your body's natural mechanism, because smoke contains all kinds of terrible carcinogens. So the body has been designed to reject and repel that smoke. You don't have to think about it. It's just automatic. The tobacco, and so cigarette smoke is the same way. You would never inhale it. You would never get it in your eyes. You'd never want it in your nose. But for the fact that the tobacco companies have engineered those products to bypass the body's natural mechanism.
That's crazy.
So
Well, I know.
they changed the pH of the tobacco smoke so people could inhale it. And they've done the same thing with the vape product.
So when I was looking on your website, a couple of things jumped out. One is 600 different ingredients in a cigarette.
That are carcinogenic, poison, formaldehyde, arsenic, the carbon monoxide.
Sounds very industrial. I mean, I don't know how you can get so many things in one, cigarette or whatever, but I guess, engineers can figure something out like that.
Well, they don't intentionally put them. They tried to take the poisons and the carcinogens out, but there's so many they couldn't do it. Just smoke has those things in it. Not any smoke, campfire smoke has it. That's why you don't breathe it. Nobody goes over campfire smoke and breathes that smoke in. No one does that.
I know, and when I'm at the camp, there's nothing really I love better than a campfire. But I do recognize that when that smoke's coming in my face, I'm moving away. And my luck, it follows me no matter where I go, left, right.
I know.
I got the wind. I see the wind coming like this, and I'm like, I'm going there, and then the wind and it's just, that's the story of life.
And you don't think, oh, there's carcinogens and poisons in that smoke.
Yeah.
Nature has given you a natural defense to protect you, Greg. But the tobacco companies have overcome, they've bypassed nature's protection for us. And that's why people die from smoking cigarettes.
All right. Well, that's going to do it for this episode of Cut to the Chase with William Ogle from Ogle Law Firm. Man has never lost a tobacco case. So listen, if you're hooked or your loved one is hooked, maybe they died, you want to call this guy, you're going to go to my show notes. I'm going to drop a link to his website so you'll get all of his information. And listen, don't start in the first place would be my first recommendation. But if it's too late and you got hooked and, you were 12 years old, you thought you were all cool, this is the guy to call to, do for you what, the most that you could get out of this terrible predicament. Anyway, William, thank you for showing up today.
Thanks, Greg. It's been a pleasure.
And, maybe we'll circle back after the Florida Supreme Court ruling on your case. I put the date in, so I definitely want to check that out. All right.
Okay, great. Okay.
All right. Okay, everybody, good talking to you too. You know what to do, everybody. Subscribe, rate, and review. If you got comments, I'm probably going to bring this gentleman back, maybe 3 or 4 months. Maybe you got a question you want me to ask him. Feel free to do it. Apple Podcasts, Cut to the Chase, you scroll down, you subscribe, 5 stars, questions, comments, anything you want. All right. Take care, everybody.